The message that I'm trying to get across here is that whoever you are, you can have mental health issues. Complex PTSD is a mental health issue. And whoever you are, there is support available. There is GP support available, and whoever you are, you should take it. And you shouldn't be worried about whether or not the family court system is going to misunderstand that or misinterpret that. Hello and welcome to this episode of the Survivor Diaries. This is an episode about a question that has come up a lot, particularly in the last week, and something that I've realised, and therefore I feel that I really need to make this episode, which is when a person needs to see the GP when they're in child arrangements proceedings. And unfortunately, what I've seen again and again is that although they need that help because of the proceedings, because of the domestic abuse, they're not taking it because of the child arrangements proceedings, and that in itself could be harmful, of course, if they are parents and if there are children involved. So this episode, it's all about the court's approach to seeing the GP if you have issues affecting your parenting in any way, shape or form, especially if you have child arrangements proceedings ongoing. The purpose of these videos is to assist litigants in person, and this is one of the messages that I want to get across that I think is really important, which is that it is fine to go to see the doctor, and I'm going to come into why that is within this vlog. Another purpose of the Survivor Diaries videos is to assist in raising good practice in the family justice system. Another reason is to get a message across about the family justice system, get it as much as we can to the family courts, to the court professionals, to Sir James Mumby, explaining that when domestic abuse has been an issue between the co-parents, it will continue through the child arrangements. And so it's spreading that message and how to deal with it, how the court should deal with it, which of course is in accordance with the revised practice direction 12J, which was revised at the end of September. Back to seeing the GP. It is very, very worrying if I am speaking to people as a consequence of doing these videos, and I've had 4 conversations in as many days with a person who has said that their view is that if you are upset or depressed or anxious, you do not go to the GP if you've got child arrangements proceedings. And I've also seen this in medical records. I'm not going to say whether they were my clients or the other parties, but I've actually seen reference from a GP saying that they would not advise taking antidepressants at this time because of the imminent child arrangements proceedings, and that could be used against this person. And I think that the family justice system, I hope that the family justice system will share my horror that people believe this. It was Mental Health Awareness Week only recently, 13th to the 19th of May. And it's not true. It's not the case that the family justice system will somehow count medical notes against you where they see any kind of vulnerability or weakness in seeing a doctor and getting help for issues arising, any issues arising, especially mental health issues. Within this episode, I'm going to explain why people have that fear and how the court would deal with, and how I expect the courts to deal with, the issues of medical records, and if this has GP notes showing anxiety, depression, things that often come hand in hand with leaving an abusive relationship, and to show why it is not an issue if those things are coming out into the court proceedings. We are looking at this fear, this message that is being given to mothers in the situation where domestic abuse is continuing through the child arrangements, misinformation which is being passed on, which is do not see the doctor, do not start taking medication because it will be used against you. It will be framed in such a way that you are a weak or dangerous mother because you are taking this medication. Is it okay for the family justice system to understand that these are the impressions of mothers coming into the family justice system? And I know I'm being gender specific. I disclose in all of my videos that I'm talking about domestic abuse between co-parents, and the prevalence of this, which happens to be from the patriarchal society and from a male to a female. Is it okay with the family courts if mothers, primary carers of the children in these examples, are not accepting help, not taking help, not going for help with their GPs in case it is used against them? This is not okay at all, and this episode is going to explain why the family court must make sure that they are consistently applying the good practice and brilliant practice that I've seen from a district judge in particular, and how they've dealt with medical records on more than one occasion. I don't believe that the court are manipulative, that they are going to use something like that against you. I've mentioned several times in vlogs, I've got a lot of faith in the family justice system. When it's getting it right, it's brilliant. It is brilliant at making orders that protect people who are experiencing domestic abuse ongoing through those child arrangements. Where does this fear come from then? Where does this fear that I've heard influential women, not just mothers, these are women who are working with other women, assisting them, supporting them. They may be domestic abuse support workers. They've possibly, like me, gone into a professional area working with domestic abuse. And this information is being passed to other mothers that you must not use your medical records or have your medical records if you've got antidepressants, and you shouldn't see your doctor. And these mothers are going through the proceedings without medical help when they probably need it. And that's not okay. This is not okay at all. I mean, I will go back. I have mentioned, I think the episode is It Can Happen to Anybody and Anyone, and I've mentioned how my own issues, I am now 7 days away from the first hearing in my own Children Act proceedings. I am a family lawyer in England and Wales. I'm also a court user because I'm about to come into the system again. Since November, I've been receiving medical supervision for PTSD, and this has involved a huge number of medications that I've never taken before. So antidepressants, taking those every day, and when I don't take those I feel very odd. And I'm taking sleeping tablets so that I can sleep because of the antidepressants, and I'm taking medication as well for anxiety. And this is all since November, in something that completely incapacitated me for 6 weeks. Totally off work for 6 weeks, on amended duties for a number of months, and now I'm in a position where I am feeling better, I am feeling stronger. The message that I'm trying to get across here is that whoever you are, you can have mental health issues. Complex PTSD is a mental health issue. And whoever you are, there is support available. There is GP support available, and whoever you are, you should take it. And you shouldn't be worried about whether or not the family court system is going to misunderstand that or misinterpret that. The view that somehow it's going to be used against a mother comes probably from the allegation from the abusive father that the mother it's an undermining of the mother. So remember the head worker, the persuader, and the liar. This is somebody who is blaming the other party and saying that there isn't abuse. It's just that the mother has mental health issues. She has depression, and therefore the abuse happens or doesn't happen quite as it was. It's actually because the mother is also abusive, because etc, etc. And the allegation comes from the abusive father, and I've seen this repeatedly. How could a mother stop this contact between the father and their child? There must be something wrong with her. There must be, it's a presumption in law, isn't it? And this is the incorrect reliance on the presumption at section 1(2)(a) of the Children Act. The wrong assumption, I've seen this quoted in the BBC, saying that there is a presumption in law that the involvement of both parents in a child's life is in that child's interest. This is my message to the family justice system, and to the courts, and to the CAFCAS workers, and to all of the litigants in person. That is not quite correct, because it can be disapplied, and you look at Practice Direction 12J, paragraph 7, as to how the courts can disapply that presumption. So there's misinformation like that. There's misinformation such as you shouldn't go to your doctors, and this is what I'm wanting the episodes to help people with, particularly litigants in person, and to spread the good practice that I have seen happening. That's where the allegation comes from, or the fear comes from, which is probably from an allegation within the C100, within the application form, which is suggesting that because the contact is not happening, and therefore that's emotionally harmful to the children, and it's actually the mother that's overreacting because of these mental health issues, it's not really abuse, and so on and so forth. And that does make people feel very defensive. More than that, when you're coming out of an abusive relationship, you don't know which end is up. You really don't know what is true anymore. It's such a complicated and strange time coming out of an abusive relationship. I really struggle to explain it in a way that can make people who have not been in this kind of relationship understand what it's like. You are questioning your mental health. You're questioning absolutely everything because you're coming out of that relationship, because you are so undermined. You're so fearful. And this can lead to anxiety, depression, all things that it'd be really good to see the doctor for. I have been receiving medical attention since November, seeing my GP regularly, monitoring the medication, different therapies, and none of this is going to count against me in my own Children Act proceedings. It will not do so, and it never has in the past. As a solicitor practicing in family law, I would not be worried if my client has examples of how she has had to consult with a doctor, to take advice from them, and to receive medication from them to help her to function as a parent because of some kind of debilitating, dysfunctional anxiety, distress that is likely to be occurring if a person is coming out of an abusive relationship. I've mentioned that the courts will not take this in a bad way. It will not count against a parent who is concerned that information about medication or therapies is going to appear in their medical records, and the court are going to see that as some kind of weakness or problematic parenting. The courts will see it as an adult experiencing difficulties. Potentially that could lead to dysfunctional behaviour, so therefore they are taking help, they are accepting help, and that is correct and the right thing to do to make them able to function as a parent in those circumstances. That's what's going to happen in my own case. That's what will happen if you are totally open with your doctor about what is going on and the distress that you may be feeling. One, coming out of a relationship. Two, experiencing child arrangements proceedings, and especially where there has been domestic abuse within that relationship. So speaking to your doctor is not something you should fear if it's something you want to do. I would be more than happy if I was a solicitor and I saw this and it showed that there's these difficulties and somebody taking appropriate steps to get help. That would be no problem whatsoever for me or with the barristers that I tend to work with. In addition to this, I'm just going to finish on again an example of brilliant practice. I have seen the same judge, a district judge, correctly seeing that the allegations of mental health issues is just a further undermining of the abused person, the abused mother in that case, and to a point that it was driving her to distraction. They've seen this with this same judge correctly identifying these allegations that are on the C100 and C1A sometimes from an applicant father saying that there must be something wrong with the mother for them to have stopped the contact. This is something that I feel quite passionate about because I have, obviously it's been Mental Health Awareness Week. I have my own experiences within the last 12 months about mental health and my own mental health and the issues there. I am 7 days from my hearing. I know that at that hearing my ex is intending to reveal all kinds of things potentially and try to shame me, and that causes a lot of anxiety. I'm in a place now where I'm going to disclose and hopefully use this with the message about the being open with your GP and medical and support services to help you with mental health if you're experiencing child arrangements. I realise that another form of control that has been used in my particular example is the fact that although I was a teacher when I was with my ex-partner, I also worked as an escort. This was fine with him right up until the point at which I wanted to leave, when of course it became the most shameful thing I could have ever done. And this is something that for years and years since I left, 15 years ago now, has always been a subtle threat coming through in text messages, coming through even in January of this year in a solicitor's letter saying, you know, we know that you work as a family lawyer and we don't want to cause you professional embarrassment, and knowing again that there's a veiled threat there. To me, subjectively, there is a veiled threat. Again, this is another let's have it all out there from my ex-husband. And I am now a family lawyer. I am now being completely open about everything that has happened. I'm hoping that gives people confidence if they are experiencing child arrangements and domestic abuse has been a feature. 1, to see their GP. 2, it doesn't matter what you've done, you can get out of this. And 3, my message that I keep repeating and repeating and repeating, which is about sharing this so that we can get consistent application of good practice in the courts, consistent following of the practice direction, consistent ability to pick up, as set out in the practice direction, that abuse is all different forms, including psychological abuse. And that's exactly what's happening when a father is saying again and again that a mother has issues, because that's obviously why they don't allow contact. If you are affected by any of the information in the Survivor Diaries, please use any of the resources that we've referred to before, such as NHS Online. Keep repeating the point that if you feel that you need to speak to your doctor, please do so. Please take other supports while you are going through the incredibly difficult process that is the child arrangements proceedings. Once again, thank you very much for watching, and I look forward to seeing you in our next episode. Thank you and bye.